Hi, good afternoon if you are on the East Coast, and good morning if you're out west. This is Aaron Lacey, and you are listening to the CARES Act for Higher Education, Strategy and Implementation, which is a webinar being brought to you by Thompson Coburn as part of Thompson Coburn's Higher Education webinar series. We hope everyone out there is safe and well and glad that you have been able to tune in with us. I'm going to go ahead and get things started with some of the housekeeping while we are waiting for additional folks to jump in. As many of you know, and I'll start with the CLE, all of our regular higher ed webinar series webinars are approved for continuing legal education. So if you are an attorney and you are tuning in today, hopefully you will be able to get CLE as a consequence of doing so. This webinar is CLE accredited in California and Illinois for an hour and a half. Of general CLE, and in Missouri for 1.8. CLE credit in Texas is pending. If you are in a state outside of one of those, you may still be able to get credit, but you'll have to reach out to the local authorities to do so. From time to time, you'll be required to click a pop-up screen that will show up during the webinar just to reflect your continued engagement. So please keep an eye out for that if you're one of the folks looking for CLE, and make sure that you tap it. Three other things. We have a Q&A widget here at the bottom of the screen, and you'll see there are several little widgets. The Q&A widget, as you would expect, is there for questions and answers. We are going to take questions at the end of the presentation. If you have one, go ahead and put it in the Q&A box, and we will get to as many as we can. I think we're all committed to sticking around for a while. We expect the content here to go pretty close to 90 minutes, but we'll hang on for at least another 15 or 20 and try to get to those questions to the extent that we can. There's a resource widget down at the bottom of the page as well where you can click and grab the slides. I'll also offer that this presentation will be available on demand on our website at a later date. Just keep in mind, if you are listening to this and it is not the original air date, that there may well have been changes in guidance or additional guidance or changes in laws and statutes, because that's what we're talking about, right, is sort of current as of the moment guidance around as of the moment legislation. So particularly for a presentation like this, if it's a later date, significantly later date, keep in mind that things may have changed. The help widget at the bottom is there for, it's got a lot of information and around particularly typical technical type questions that people may have during the presentation. So if you're having some sort of technical issue and you can get to the help widget, please be sure to check it out. Finally, at the end of the webinar, there will be an opportunity to fill out a survey. We deeply appreciate it when people take the time to fill out those surveys. We take them very seriously. We always review the responses because we want to try to make a presentation better than the one before. I mentioned earlier, this is being brought to you by Thompson Coburn LLP. So we're a law firm based in St. Louis, Missouri, but we have offices all over the place in cities like Chicago, LA, St. Louis, Dallas, and DC. And we're proud of the work we do. We're pretty big. We have nearly 400 attorneys, so we have folks in lots of different practice areas. I am the chair of the practice, the higher education practice. There's a picture of me with a hair. We'll just all pretend that that's what I look like today. I'm definitely not sitting here in t-shirts and a baseball cap. If you'd like to contact us at any point to ask questions about higher ed, please do so. Today, I'll be presenting and offering thoughts, but I'll also be joined by four great attorneys in our practice. Katie Wendel, who does a lot of different things, but higher education regulation and compliance is top of her list. She'll be talking about some of the Title IV waivers in the CARES Act today, among other things. Katie holds an MS in higher education administration, so she hasn't always just been an attorney, and clerked for a while for NACUA, which is the National Association of College and University Attorneys, has higher education in her blood. Scott Goldschmidt specializes, again, in a lot of different things. He was the former Deputy General Counsel at Catholic University. So in that role, like all general counsels, handled a wide range of issues and affairs, but does a lot on the front of student and faculty affairs and institutional contracts for us. I'm very pleased to have Sean Crowley with us today. He manages tax matters for a lot of our higher education clients and has been paying particular attention as you would expect, to the tax provisions in the CARES Act. They are important, and based on my conversations with clients, not necessarily top of mind. Some of them actually have the potential for immediate relief, and Sean, I'm thankful you're here today. Sean's going to talk to you about those tax provisions. He is also a triple Hawkeye, and that is to say he has 3 different degrees from the University of Iowa. I told my kids I had a triple Hawkeye on the presentation, and they were excited until they realized that had nothing to do with the Avengers. Finally, Chris Murray, our resident lobbying and policy expert. Chris is the co-chair, actually, of the firm's lobbying and policy practice, but he specializes on education and higher education policy. He will probably be joining us at about 60 minutes at the top of the hour to talk about what's coming down the pipe in Congress and on the Hill, because as many of you know, there are some fairly important things being discussed today. He's been in the space for about 15 years, and I love this fact about him. Chris clerked in the Caribbean, and it was only after I met him that it dawned on me that that was even an opportunity, and unfortunately one that I sorely missed. So this is what we're going to talk about sort of in order. I'm going to start out with some discussion about some critical resources. You know, part of our goal, and let me just take a deep breath here and say, we're going to throw a lot of information at you. Try not to absorb all of it at once. I think if you do that, you will be frustrated and unhappy. That's often the experience. What I would suggest is let it wash over you. Take what you can. Watch out for the points that we stress where we say this is really a key or critical thing. And remember, this presentation is available on demand, and you've already got the slides. You can download them right now. So you can certainly go back and review things again in time. You don't have to figure it all out right away, okay, because it is a lot of content to take in at once. I want to also make sure that we're giving you as many tools and resources as we can in addition to what we're directly talking about. So we've got links throughout the presentation. If you download this presentation, those links are all live in the PDF, so you can click them and it will take you to the linked resource. So I'm going to start out with a conversation about some critical resources. I just want to highlight some things that if you're responsible for these kinds of things at your institution, you should have these bookmarked in your browser. Then we're going to talk about what I think is probably the piece of the CARES Act that's top of mind for most institutions right now, and that's the money coming in through the Higher Education Emergency Relief Fund, or the HERF, as the cool kids say. We're going to talk about distribution strategies as well. Then we're going to get into higher education regulatory relief. Katie's going to cover that. What we're talking about here are the provisions in the CARES Act that alter the administration of Title IV, federal financial aid. Sean, we have promised him that we're going to get to tax relief by the 45-minute mark. And then we're going to spend the last little bit talking about Main Street Lending Program, Paycheck Protection Program, and the Economic Injury Disaster Loan. We know that 2 out of the 3, most of you are probably already pretty familiar with, that being the Paycheck Protection Program and Economic Injury, but we want to at least touch on them and where they are in the status because we think they may receive additional funding soon. And we also want to talk about the Main Street Lending Program from the Fed Reserve because it is still on the way and may prove an opportunity for a lot of schools and businesses on the line. Finally, again, Chris Murray, we hope will join us here in the last 30 minutes and be able to talk a little bit about what's going on the Hill. And then from there, we will move on to questions. So keeping it crisp, taking a deep breath, let's talk about some critical resources. Every time you see one of these pages in our presentation, it's more like a little web screen, you can click on that and it will take you to that page. So the link is embedded in these graphics, okay? The first 2 resources I want to flag for you, the one on the left, that's the act itself, the legislative language. If you don't have a copy of that, you ought to. It always is worthwhile, particularly if you are one of the lawyers of a line, of course. But even if you're not a lawyer, even if you're a compliance professional or other person, it's worth having that act right there at your fingertips. By the way, through the presentation at a number of points, we've tried to include in the lower right-hand corner the citation to the place in the act where you will find the quote or the concept that we're talking about, and now you can when you pull up the act itself, you'll be able to find it more quickly. On the right, The Congressional Research Service, these are the smarty pants that actually the folks in D.C. who write reports for Congress, and they are smarty pants. They're some of the best and brightest on the block. So when Congress wants information about anything, they go to these guys and they say, we need a report about this, or we need an analysis of that. So they did one, it's just 2 pages long, and it summarizes the CARES Act provisions that are specific to higher education. So it's not going to talk about, tax credit opportunities that are available to all organizations or businesses, but it does capture all the provisions that are specific to higher ed. Again, it's only 2 pages. It's concise. It's a really nice resource, so I suggest that folks familiarize with it as well. From the department, there are 2 web pages you need to have on your browser. The first on the left is the COVID-19 page that aggregates all of their resources and content related to COVID-19. Highly recommend it. Keep in mind there is some stuff here about elementary and secondary, but there's a whole section specific to higher ed. On the right is the department's page specifically for the CARES Act. And this is an important page to have. I mean, obviously it's got the critical information, but I also noted there's something wonky going on with the department's website, and there's another section that appears to have information about the Higher Education Emergency Relief Fund, and it does not. I don't know who created it over there, and it may just be the left and right hand don't know what they're doing. This is the page you want. This is where the department is actually making the information available. And we expect when additional guidance comes down, and we anticipate that it will come down soon, this is where it's going to be posted. You can also keep an eye out on the electronic announcements on the IFAP page, where just about everything is posted eventually as well. Finally, if you're like me, you're getting 100 emails a day in your inbox about the CARES Act, and everyone you've ever to has issued some sort of blog post or alert or announcement. You've probably received several from Thompson Coburn. I appreciate that it can be a little overwhelming. All the trade associations in D.C. are tracking CARES Act provisions, including pretty much everybody that has anything to do with higher ed. And many of them, by the way, are doing a great job. ACE is doing a great job, NACUA, NICU, all those guys. But there are 2 that I want to point you to. The first on the left is NASFA, right? This is the National Association of Financial Aid Administrators. Their coronavirus web center is superb. They're doing a great job of tracking everything. They've had podcasts. They've had webinars that are timely. They are in good communication with the U.S. Department of Education. The only caveat I would offer out is, we're talking about the CARES Act today, right? And we're specifically talking about the provisions in the CARES Act, and that includes some provisions that Katie's going to talk about later that deal with Title IV and waivers for Title IV. Keep in mind that the U.S. Department of Education started taking steps and creating flexibility for institutions before the CARES Act was enacted, right, which was on March 27th. So for several weeks prior to that, the department, under existing authority and within the context of existing sort of legislative and regulatory flexibilities, was already taking steps. So their guidance around, for example, distance education and the flexibilities around distance education, that predated the CARES Act. Why do I bring this up? Because NASFA, as you would expect, was covering that guidance. So when you go to this website, you're not just going to see information about the CARES Act and the waivers in the CARES Act. You're going to see information about all of the activity at the U.S. Department of Education, a significant percentage of which predates the passage of the CARES Act. And I need you to be mindful and be careful that if you are looking at Q&A or you are looking at guidance, whether it be on NASFA or on the department's website, that predates the CARES Act, it is possible that that guidance has been superseded, right? Because the department, when it issued some of this earlier guidance, was only doing what it could do within the bounds of the current statutory framework. The CARES Act altered that statutory framework and created additional flexibility for the department, right? So what you've got to do is just be really careful that you are digesting the current state of affairs that takes into account the CARES Act and other legislative activity. So if you're looking at guidance, whether it's on NASA's website or on the department's website that's from early March or mid-March, please just keep in mind that some of that could have been impacted by the CARES Act itself. and may still be impacted in the future by additional guidance or from the Department of Legislative Activity. It's a very fluid environment, and you just want to make sure that you are zeroing in on the current state of affairs, right, with regard to these various issues. On the right, I've got the website for NACUBO, the National Association of College and University Business Officers. These are the CFOs and the accountants and the comptrollers at institutions of higher education across the country. So what I've given you here is the website for the folks who manage financial aid and the website for the folks who manage the business office. And if you want to talk about who's really paying attention to the flow of funds, these are the guys. So I highly recommend that you pay attention to both of these associations, and they're both doing really good work. All right, so let's move on to the Higher Education Emergency Relief Fund, and to provide sort of the overview, I'm going to pitch it over to Scott Goldschmidt. Scott, take it away.
Thanks, Aaron. I sure appreciate that. Just to note, we realized, and thanks for the Q&As, that there were some issues with the slides, and we'll work to address that as we go. So first, the Higher Education Emergency Relief Fund. So of the $2 trillion in the CARES Act, approximately $30.75 billion is allocated to the Education Stabilization Fund, and approximately $14 billion of that is allocated to the Higher Education Emergency Relief Fund, which, as Aaron mentioned, acronym is HERF, which is a fairly terrible acronym, but I guess we have to go with what Congress gives us. Of the $14 billion in the Higher Education Emergency Relief Fund, $1 billion is allocated for minority-serving institutions on top of their other allocations. $350 million is allocated in grants to institutions particularly impacted by COVID. And what we'll be spending most of our time on, as you can see in the yellow outline on the slide, is the $12.56 billion in aid to institutions of higher education to prevent, prepare for, and respond to COVID-19. So allocation numbers are already out. Institutions likely should know how much they're expecting as part of this fund, and if not, that's on the Department of Education website. But in case anyone's curious about how the numbers were arrived at, 75% of what each institution received was based on its relative share of full-time equivalent students who are federal Pell Grant recipients, and 25% is based on its relative share of full-time equivalent students who are not federal Pell Grant recipients. Students enrolled exclusively in distance education courses are excluded from the allocation calculations, but there's no restriction for an institution to provide them aid. The guidelines for the use provided by the Act: at least 50% of the funds must be used for emergency financial aid grants to students. I know this is on the minds of a lot of institutions, and Aaron's going to be going into greater detail into this in the next section. But as an overview, the CARES Act itself specifically states that the student aid grants must be used for expenses related to the disruption of campus operations due to COVID-19. The law also explains it would be proper for students to use funds to cover eligible expenses under their cost of attendance. And the Act explains such as food, housing, course materials, technology, healthcare, and childcare. There's nothing preventing an institution from providing more than 50% aid to the students. On the flip side, up to at most 50% of the funds can be used to cover institutional costs. The Department of Ed has not promulgated guidance on the use of these funds, but based on the statutory language, we think that institutional use is meant to be broad and based on the overall purpose of the funds that I discussed in the last slide, which is to prevent, prepare for, and respond to COVID-19. The statutory language permits, as shown on the slide, that institutions may also use the funds to cover costs associated with significant changes to the delivery of instruction due to COVID-19. Congress has chosen to prohibit only a few rather egregious kind of out-of-bounds activities for the funds, uses for the funds. For example, Congress does not want an institution to use the funds on their endowment, or to build a church, or a football stadium, or those instances like that. So on April 9th, the Department of Ed published those allocations and methodologies. As Aaron mentioned, links to each are live, and if you have any questions, certainly click on those and can learn more about them. Also on the Department of Education webpage. Secretary DeVos's letter to institutions is also linked, and that letter has some useful guidance regarding the intent of the Department of Education. Institutions, oops, I think I went too far. Sorry. Institutions must also complete a funding and certification agreement for this first allocation. This funding and certification agreement contains a number of conditions that institutions must agree to in order to receive funds, and then institutions will draw down the funds through the agency's G5 system. While we've heard from a number of clients that there have been issues with grants.gov and the application system, we have not yet heard that anyone's received the aid. More guidance on this particular tranche of aid has been promised any minute now, and we've been checking the department website fairly frequently, but at the start of this webinar, nothing's been received yet. We'll certainly be providing updates as they're available. Ed is working expeditiously to allocate the remaining funds. That's a direct quote. We're not quite sure what that means, but Ed was quick to deliver the first tranche of funds. They kind of beat everyone's expectations. So we're hopeful that they'll be quick in allocating the rest of the funds. And with that, I'll turn it back to Aaron. Aaron, are you there? Aaron, looks like you might have dropped off for a sec. And again, we apologize. Usually, you're there.
I'm back on. I'm back on. There you go. Thanks, Scott. Sorry about that, guys. Yeah, so I want to focus here. I think the distribution methodology is top of mind for a lot of people. And I'm going to start by walking through, as Scott mentioned, we don't have any guidance from the department. What we do have are some public comments made by officials, some comments that have made in private meetings. But mostly what we've got is the language of the funding and certification agreement itself, which in some cases offered a little more meat on the bones as compared to the language of the CARES Act itself. And then once we get through sort of what we do know, we'll speculate a little bit around best practices and what we think is probably coming from the department in the guidance. First of all, on qualified expenses, the CARES Act states that the grant, and Scott mentioned this, to students. So I'm really focused here on how you guys are distributing those emergency financial aid grants to students. That's the first tranche of funding that we're going to get first, right, as institutions. Also, as I mentioned, to our knowledge, no one has yet received that. And I'll also just reiterate, if you have been frustrated dealing with grants.gov, if you are still trying to get Duns & Bradstreet to update information or something to work in SAM.gov, you are not alone. The funding has not come through yet, and remember, you have some time to figure out how you're going to disperse it and to get it to students. So my advice is just to work through those processes as expeditiously as possible and know that you are, again, not alone. Cold comfort, on the other hand, misery loves company. So when you do get those funds, let's talk about what they can be used for. First of all, qualified expenses. CARES states that the grants to students are, quote, for expenses related to the disruption of campus operations due to coronavirus, including eligible expenses under students' cost of attendance, such as food, housing, course materials, technology, healthcare, and childcare. So this focus on cost attendance is not throwaway. That has popped up several times. On the other hand, the language in the CARES Act and the Secretary's letter does note that it's not exclusive, right? It says including eligible expenses under a student's cost of attendance. So in theory, if you're reading the plain language there, it could mean that there are ostensibly some costs that would be related to the disruption of campus operations due to coronavirus that might fall slightly outside of the list that's enumerated here on your screen, or detailed on the screen. The Secretary also acknowledged in her letter that the only statutory requirement is that the funds be used to cover these expenses. So it doesn't really go any further than this. That takes us to this theme that we've already hit on before and we'll continue on, which is there's a lot of discretion for institutions here. There's a lot of discretion. Okay. So distribution discretion, right? The CARES Act actually says institutions have the discretion to determine the amount of each individual's emergency financial aid grant consistent with all applicable laws, including non-discrimination. So this means, and this is from the Secretary, this means that each institution can develop its own system and process for determining how to allocate the funds. The Secretary also noted that that can include distributing the funds to all students or only to students who demonstrate significant needs. So, we've been getting a lot of questions from clients. Some have said, could we distribute everything just in an even amount? Could we do a couple of tranches? Could we use, Pell Grant eligibility or EFC and just divide our students into 2 or 3 groups? Could we do some sort of solicitation or application and really try to do an individualized assessment of every single student? And the answer to all of those questions is yes, or at least would appear to be yes. Now, we do anticipate further guidance from the department. Our expectation is that guidance is primarily going to focus on the mechanics of distribution, whether that be through your student ledger, an account system, or should be, direct distribution along those lines. I don't think you're going to see much walking back or change to this fundamental concept, which is ultimately the determination of the methodology for distribution and how much to distribute to individual students is left to the institutions within the sort of large parameters that the department has given us here. All right, so what suggestions has the department made? And these are suggestions. These are not requirements, so that's an important point to keep in mind. Be mindful of each student's particular socioeconomic circumstances. So the department seems to be suggesting, encouraging institutions to try to do some level of analysis, but again, it is not required. These are suggestions. Prioritize students with the greatest need. Consider establishing a maximum funding threshold. Right, and the Secretary recommends the maximum Pell Grant, though that is really, in my mind, fairly arbitrary, right? I mean, the idea is just it's not required. The idea is just that you may want to come up with some cap. And if you do tranches, maybe you do $2,000, $4,000, and $6,000 grants, right? Or something simple along those lines. And finally, they've encouraged institutions strongly to use professional judgment to adjust EFC to exclude grants. If you don't know what that means, just ask your financial aid office and they will be able to tell you. And that is something that institutions will likely want to do and that your financial aid folks can take care of. So let's talk about certifications and limitations. You do have to fill out this certification agreement, funding and certification agreement. And there are certain things when you do that, and many of you have probably already done it, though you may not recall everything that there are things you are certifying to be true as part of your agreement to participate in the program and receive the funds. You have to, among other things, certify that you will make the grants promptly, so you have up to a year to do that, to get all the money out. But there is this expectation that you will be prompt in the way you go about administering the program and that you will make the grants, quotes, directly to students for the qualified expenses we talked about on the prior slide. An institution is expressly prohibited from using the funds to, open quote, reimburse itself for any costs or expenses, including but not limited to any costs associated with significant changes to the delivery of instruction due to coronavirus, or any refunds or other benefits that the school previously issued to students. So I know there's been a lot of conversation around, and we certainly received a lot of questions from clients. What if we already issued grants? What if the student has an outstanding balance on their account? What if we expect in the future there are going to be amounts owed? To what extent can we use these funds to either reimburse ourselves for money we paid out or to apply against amounts owed to the institution? And my answer to you is you're not supposed to do that, right? I mean, I've heard other associations talk about this, and I think we will absolutely receive some more definitive guidance from the department. But the really short and simple answer is that's not the purpose of the funds. The purpose of the funds is to take those monies, distribute them out to students. And the metaphor I've used for some of my clients is sort of like the sprinkler in the yard, right? I mean, the funds come in through the hose, and the institution's responsibility within the parameters and guidelines, you can decide how fast you want the sprinkler to run, which part of the yard you want it to run on, right? But at the end of the day, all the water is supposed to be spread on the lawn, right? None of it is supposed to go back and reimburse the institution. And we think, and I'll get into this in the best practices section in a minute, that it really makes sense to avoid any sort of deliberate relationship or connection between your student accounts and the funds that you're putting out there. Okay, timing and documentation. I mentioned earlier you have to certify that you'll promptly put the funds out there. You also have to certify that you'll promptly and to the greatest extent practicable distribute the grants to students by 1 year from the date of the certification. This doesn't mean you have to wait a year, but it does mean you have up to a year. We think it's the best practice. And keep in mind, we're attorneys, we're risk managers, so we like systems and approaches that limit risk. We think that the longer you sit on funds, the more problematic it becomes. I think for public relations reasons and lots of other reasons, it's probably good to get these funds out as soon as possible, at least the bulk of them, understanding you may want to do some sort of holdback. That is to say, institutions couldn't distribute in tranches spread over several months. It's not to say there aren't lots of great reasons to potentially do that. I'm just suggesting that the longer you sit on those funds, the more problematic it becomes, and the higher the risk that people are going to ask questions, whether that's a watchdog or your students or a regulator, why you haven't distributed funds, where did those funds go? Because remember, all those folks got them. The allocations are public, right? So having a clear communication to your constituents, they're going to be distributed, et cetera, is incredibly important, and getting them out the door is important as well. The other thing that's important to keep in mind, remember 2 or 3 slides back, we said the purpose of these funds is to address student expenses that were incurred as a cause of the disruption on campus related to coronavirus. The other thing to keep in mind is as we get further and further out from sort of present day and you enroll students down the line, you know, if you're back on campus and operations are back up, you've got new students enrolling and you've saved money for them, there could be some question as to whether they really had expenses relating to the disruption on your campus caused by coronavirus. Right? If 6 months from now you're largely back to running things as usual and you're enrolling new students, they may not have those qualified expenses, right? So that's something else to keep in mind if you're holding back tranches, is whether you will be able to still find students with qualified expenses. I'm sure you'll have students who would suggest that they have qualified expenses, but that's a different question. Reporting and workforce. So the agreement specifies that schools shall report 30 days from the date of the FCA, that's your agreement, and every 45 days thereafter, how the grants were distributed to students, the amount of each grant awarded to each student, how the amount of each grant was calculated, and any instructions or directions given to students about the grants. So a couple of points here. The first is, if you weren't sure whether you had reporting requirements, you most certainly do. The second is to keep in mind that, you know, the better job you do keeping things fairly simple, the easier it will be to track and report all of these things. Again, we on the attorney side of the aisle tend to like keeping things simple because we think it makes it easier to administer consistently and track and report. Number 2, you also need to document that the school continue to pay all of its employees and contractors during the period to the greatest extent practicable. So you know, there were other programs like the Paycheck Protection Program that had hard metrics about how many of your employees you're supposed to keep employed. That's not the case here. We're really talking about an urging of institutions to do what is practicable, so it's not a hard requirement, but there is an expectation that you will make an effort. And the real reason I wanted to highlight this is you need to document how you went about complying with and your efforts to comply with all facets of your participation in this grant program. And this is one of them. So wherever you are keeping at your institution, whether it's on electronically or a physical file, wherever you're keeping all the documentation that concerns your participation in this program, all of the stuff you see there, number 1, that you're going to have to report, you know, your internal protocols, you need to be prepared to document number 2 and keep it in that same file, because when you get audited, right, or somebody comes calling to see if you made every effort to keep folks employed to the greatest extent practicable, you're going to want to be able to put your hands on whatever documentation or memo to file you have that justifies your efforts in that regard and explains your efforts in that regard. Okay. let's talk about audit rights. So the other thing to keep in mind is that when you participate in this program, you are subjecting yourself to the department and its Office of Grant Management and the various regulations and statutory authority that they look to. And among those are you're agreeing that you will allow the department to examine records with respect to the funds received, as well as other agencies. So it could be the U.S. Department of Ed or its Inspector General, the department, any commission, and the lawful exercise of jurisdiction and authority. So all of this is just to say, once again, when you sign on to this agreement and you take these funds, the department already has lots of ways to look into what you've been doing. Congress, my guess is down the road there will be some sort of oversight committee that will be formed specifically to follow up on CARES Act expenditures. Anytime the government has had a massive funding program like this, there's always fraud, abuse, and waste, and there are always folks who, after the fact, make a reputation hunting that sort of stuff down. So that means people are going to be looking under the hood. They're going to be asking you how you complied with the program. You know that's coming. So please, please, please document everything, right? Okay. Laws and liability. The other thing you should be aware of is that you're subjecting yourself to some regulatory oversight that it's passed in the past. It's possible in the past you weren't subjected to. So large institutions, R1s, research folks who've received a number of grants already, you may already be familiar with some of these laws, but for smaller schools, regional private, some proprietary institutional grant funding, just keep in mind, you've now got a new regulatory framework that you're dealing with. It's going to feel in some ways a lot like the other regulatory frameworks that you already deal with because you guys as institutions of higher education are so heavily regulated. But it includes, and it will not surprise you that it includes lots, again, of audit rights, of reporting obligations, and creates exposure for you in certain respects. Anytime you participate in a program where the federal government is giving you money, you're always going to have a False Claims Act exposure and things along those lines, right? So just keep all of that in mind. Okay, so let's do a lightning round here. I've got two sort of lightning rounds. One is on best practices and the other is on outstanding issues. Okay, best practices. First of all, take your time. Again, the funds haven't even hit yet. There's nothing that says you have got to take this money and distribute it right away. Right? Obviously, and I said earlier, I think you want to try to get it out the door sooner rather than later, but take your time. Make sure that you've got your protocols set. You've figured out how you're going to distribute the funds. You figured out how much different students are going to get, whether you're going to have a reserve or not. Figure all that out in advance. You can tell I'm from the Deep South. We do a lot of figuring. Figure all that out in advance, and then document it, and document it again. Right? The department is handing out billions of dollars. The federal government is handing out billions of dollars, or trillions rather. It's really important to document everything because folks are going to be following up. I've already mentioned we like the idea of keeping methodologies simple. That is not to say that a complex methodology would be inappropriate or prohibited. You might have a great methodology that's extremely complex, but you think is going to put the money in the hands of the folks who need it most. I'm just telling you, the more complicated it is, the harder it is to administer, the harder it is to explain to students and other constituents, etc. If you keep it simple, you can get it out the door quickly, or more quickly. It'll be easier to track and easier to explain. And it decreases the likelihood of error and inconsistency. Run advanced scenarios. I strongly recommend that folks, before they actually start putting money out the door and into the hands of students, model it out and make sure you have a good sense as to how much each student's going to get, right? And see if you can run various scenarios and see if different scenarios make more sense to you all at the institutional operational level. Again, we like the idea of getting the money out sooner rather than later. Even if you are holding back some amount for special needs or something along those lines, we think institutions will be best served by getting it into the hands of the students. We do not like connecting the distribution formula to institutional expenses or refunds in any way. I don't think there's anything right now that prohibits you, for example, from running the funds through your student account system and posting them to the ledger. But if you do that, you know, you have to be extremely sure that they aren't inadvertently netted out against outstanding balances, right? I mean, just because that is prohibited. That's clearly not what's supposed to happen. We like the idea of doing this outside of your student ledgers, your typical account system, if it is feasible to do it, right? If it's feasible to do it. We also like the idea of having a separate bank account. I've seen various accounting firms, associations, and others recommend this. We think it's a great idea. You designate it as a federal funds account, the money goes into that account, and you distribute it directly out of that account. From an accounting perspective and an audit perspective, it will make things so clean if you can do that. I know some folks can't, but if you can, we think it would be a real advantage. Have students certify need and the understanding of the qualified expenses. So there's a lot of conversation around, should we have an application? Should we solicit from our students, you know, whether or not they have one of these qualified needs? I heard another association the other day really liked the idea of an application, but seemed to think that a certification, acknowledging receipt of funds, maybe wasn't necessary. So I'm going to take a different position. I frankly, and I think the folks in our shop, we think soliciting need and creating some sort of application is less important, right? Because first of all, I think if you send something out to students saying, do you have need in these areas, they're all going to say yes. I just wonder how much you're really going to learn from that exercise. Also, if you send out an application or some sort of solicitation, and that has to be completed prior to you developing your distribution process or them getting funds, it's just creating one more step in the way of getting the funds out the door. What we do like, and actually would strongly recommend, is that you have in the least some sort of certification document that students would get, and it would describe the loan program, or the grant program, how it works, the parameters, at least in brief, maybe your distribution formula, and it would also say these are what the qualified expenses are, and we have, based on our formula, determined that you'll get a grant of $2,000. Please certify that you understand the qualified needs and that you have qualified expenses, and that you have qualified expenses in this amount or more. And my expectation is your students will sign that and say, yes, I do, and give it back to you. And it gives you documentation that you explained this to the students, that they had certified, that they had expenses in the amount or even exceeding the amount that you were giving them pursuant to your formula, and it serves as somewhat of a receipt. Again, we're lawyer types. We're not financial aid professionals or others. We like to mitigate risk, and for us, the idea of having something in writing where a student certifies that they had that need or more, and that they received the funds is important. We don't want to create too many barriers, but we think this kind of documentation is important. And keep in mind, remember on one of the prior slides, one of the things you have to report to the department per your agreement is how you inform students of the grant protocols. So this would be an answer to that, right? Finally, keep up with the critical resources. Review that stuff daily if you can. Okay, outstanding issues that we think will likely be addressed shortly. Whether or not you could, for example, have students opt in to apply the grant against their outstanding balance. So, you send them something and you say, before we give you this money, we expect to give you $2,000, but would you like us to just apply it to your grant, your outstanding balance? We think that's a bad idea. Again, I said earlier, even if the department permits that, I think it's a bad idea. We think that the purpose of these funds, the congressional intent, was to get them out to students. But there may be more guidance from the department. We do expect something in the next 2 or 3 days, and it could address that point more explicitly. And if the department says it's okay, you can certainly can and should take that into consideration. Undocumented and international students is still sort of an open question. There's nothing in the CARES Act that suggests that you cannot distribute funds and include these students in your pool when you're coming up with your allocation formula. That having been said, there does seem to be some question around whether undocumented students are eligible or not. One approach might be, and we think the guidance from the department that's forthcoming may address this point as well on undocumented international students. We know NASFA has been asking the department about that specifically. So maybe what you want to do is set up your distribution formula so that you hold some money in reserve for these types of student populations, right? Pending guidance from the department. The other thing is I expect that guidance is going to show up before any of us get any money anyway, meaning the institutions out there. So you should have this information, hopefully, before you even finalize your distribution formula. Eligibility of students who withdrew and future starts. So what the CARES Act says is that students, right, are eligible for these grants. So if someone has already withdrawn and is no longer a student at the institution, it would not appear that they would be eligible to receive a grant. Similarly, if someone has not yet enrolled, let's say they're in your pipeline, but they're not registered, they're not yet a student of the institution, it would not seem that they would be included in that pool. That having been said, you could always hold back funds for individuals who you anticipate will become students in a month or 2 months or 3 months if you believe that they will have qualified needs and you want to approach things that way. Eligibility of strictly online students and non-Title IV students. Neither of these groups is excluded, and I'm not seeing any discussion anywhere that suggests that they even might be excluded, right? So the way the CARES Act is written and everything we've seen indicates that if you want to include strictly online students or your non-Title IV eligible students in your pool, you can do that. The purpose is to address their need. We talked about application student surveys, et cetera, and we talked about the ability of institutions potentially to offer one grant for all, grants by groups, or to do an individual assessment. All of that be okay, just keep in mind the trade-offs around complexity. Okay, so with all of that being said, Katie, I'm gonna get it to you. I know we promised Sean we'd hit him by 12:45, so I'm already running us behind. Let me ask that we try to get through the Title IV relief in about 10 minutes, and then Sean, we'll just pitch it to you. We'll be a little behind, but I think we'll still be okay.
All right, I'm on the clock. Thank you, Aaron. So before I get into the nitty-gritty of the regulatory relief found in the CARES Act, I did want to touch on an important distinction that Aaron mentioned earlier. So prior to the passage of the CARES Act, the department issued those two pieces of guidance, and they issued the initial guidance on March 5th and then followed it up with an FAQ page on March 20th. So as he said, all that guidance predates the CARES Act and was based on flexibility the department had under existing laws. And then with the CARES Act, which as we noted came out on March 27th, Congress created these new laws to reflect these regulatory changes. So then when we saw the April 3rd guidance from the department, that's where they tried to meld together the guidance they had issued prior to the CARES Act and then some of the changes made in the CARES Act. So this timeline is important because some guidance that was issued earlier in March was then changed by the CARES Act. And as Aaron mentioned, just be careful as you are looking at resources. Just keep in mind that anything issued prior to March 27th might still be the prevailing guidance, because it might not have been addressed in the CARES Act. Off the top of my head, Distance Education Act requirements and FERPA were not addressed in the CARES Act, while other early guidance from the department has been replaced with Congress's language in the CARES Act. So the Federal Work Study Program is a great example of that. I also want to quickly point out a particular line that bears on this point. The department recommends in its guidance from April 3rd that institutions document in their records as contemporaneously as possible any actions taken as a result of COVID-19, including those actions described in the guidance from the department as well as the CARES Act. So the department knows how difficult it is to navigate all of this, and I thought that was a great note of advice from them, something just to keep in the back of your mind during all of this. So I just want to point out again, this webinar is focused solely on the changes made by the CARES Act, so the guidance on topics not addressed by the CARES Act, like I mentioned, Distance Ed, the CLEARE Act, those could be their own webinar, which is not today. So we won't be discussing them now. We're just focused on the regulatory language and relief created by the CARES Act specifically. That is a good segue into our next slide, where we wanted to make the point that while the CARES Act temporarily modifies some Title IV requirements to ease the burden on schools and borrowers, it does not give the department broad authority to grant statutory or regulatory waivers to schools. So there were some early drafts of the CARES Act legislation that included that language that would have done so, but it did not make it into the final bill. Importantly, this means that until further legislation is passed, statutory and regulatory deadlines and requirements remain unchanged. So please keep that in mind as you consider your compliance calendars and obligations. And so this next slide really just kind of gets into what I have already discussed, the status of the implementation, that most recent guidance on April 3rd, that is the most current that we have on regulatory relief. And as Aaron said at the top, we've been eagerly awaiting the department's additional guidance, so we will keep a lookout for that and hopefully see it soon. Also, as Aaron said, hopefully not immediately after this webinar, but I guess we'll see. Sooner the better, really. All right, so one of the important changes, flexibilities that the CARES Act offers is return to Title IV relief. Non-COVID-19 circumstances, if a student withdraws from a school before the end of a period of enrollment for which federal student aid funds were dispersed, the school and or the student may be required to return grants and student loans received for that period back to the department. The CARES Act requires the Secretary of Education to waive that requirement that schools and students do so in the case of students who withdraw as a result of COVID-19. So please note that this does not apply to assistance received as part of federal work-study programs. So schools must still perform the return of Title IV funds calculations. They still need to report that number of Title IV recipients who withdrew, the amount of grant or loan assistance, and importantly, the total amount that is not being returned to the department. So this kind of goes back to that advice in the department's guidance regarding documenting everything, and in particular, anything done in response to this CARES Act flexibility and your COVID-19 response. So here is some flexibility that will be important for your students and important for you to understand to support those students and your FSA office. A student's obligation to return Title IV aid is waived if the student withdraws due to COVID-19, and a student's obligation to repay loans is canceled if the student withdraws due to COVID-19. Additionally, institutions may, as a result of COVID-19, provide a student with an approved leave of absence that does not require the student to return at the same point in the academic program that the student began the leave of absence, as long as the student returns within the same semester. So the CARES Act is providing some flexibility there, recognizing that students might have some circumstances that make even more flexibility necessary for them to get through a program and even a semester. So under the Federal Supplemental Educational Opportunity Grant Program, authorized under the Higher Education Act, schools provide grants to undergraduate students who demonstrate exceptional financial needs. The CARES Act authorizes expansion of that program to allow schools to provide emergency grants to undergraduate and graduate students for unexpected expenses and unmet financial need as a result of COVID-19 and its fallout. Under the CARES Act, schools are permitted to transfer up to 100% of their federal work-study allocation to the Federal Supplemental Educational Opportunity Grant Program, that's a mouthful, during this period of national emergency. So Congress is giving some additional flexibility to schools to determine the best use of those funds and really figure out who can best use them and where they should allocate those funds. As I am sure you are all aware, under the Federal Work-Study Program, schools provide part-time employment opportunities for eligible undergraduate, graduate, and professional students. The CARES Act permits schools to continue paying students who participated in the Federal Work-Study Program but were unable to fulfill their work-study obligation due to COVID-19. Please note that schools can make those payments as a one-time grant or as multiple payments to the Federal Work-Study students. So this applies to a student who maybe works in the school library for 10 hours a week and earns money through the Federal Work-Study Program. Clearly, with campus closed, she is unable to work in the library, shelving books and helping students. That allows the school to pay her anyway. Now let's say a student provides online help for students through the school library, and she's still able to do that work from home in an online environment. However, let's say she has decided not to do that work right now for whatever reason, even though she is able to perform her job. So under the CARES Act, she is not eligible for these work-study funds because if she does not do the work, because she is able to do the work. So just be sure to do that analysis for students in your work-study program. Under normal circumstances, schools provide institutional funds to match federal funds received under the FFCRA grant program and the Federal Work-Study Program. The CARES Act requires that the department waive those matching requirements under these programs for funds made available for award years 2019 and 2020 and 2020 through 2021. So this applies to all schools, both nonprofit and for-profit. Private for-profit organizations that employ federal work-study students and are not institutions of higher education are required to continue to provide a match in those funds. So we've heard some confusion around this distinction, but want to be clear that the waiver applies to all institutions of higher education. All right, so I've got just a few kind of quick highlights of a few other regulatory changes under the CARES Act, and then we'll pass it over to Sean. So Pell Grants provide grants to financially needy undergraduate students, and students are generally limited to the equivalent of no more than 12 full-time semesters of Pell Grant awards. The CARES Act permits any semester or equivalent that the student does not complete due to COVID-19 to be excluded from such limit. So some nice additional flexibility there. The next one, to be eligible for federal student aid as authorized under Title IV of the Higher Education Act, a student must make satisfactory academic progress as measured through qualitative and quantitative standards. The CARES Act excludes attempted credits that were not completed due to COVID-19 from the quantitative component of that STAP equation without requiring the student exclusionary. The HBCU Capital Financing Program, authorized under the HEA, assists historically Black colleges and universities in receiving low-cost capital financing and maintenance construction projects. The CARES Act authorizes the Secretary of Ed to grant a deferment during COVID-19 for an institution that has a loan under the program. So that means during this period of deferment, the Secretary is required to pay the required principal and interest due, but then at the end of the deferment, the school will be required to repay the Secretary for payments made on its behalf. Additionally, Ed may also waive eligibility and reporting requirements for schools participating in the Minority Serving Institutions program. So please note that the Secretary may, she is not required. Let's see, the CARES Act authorizes the Secretary of Education, upon request by an affected institutional grantee, to modify the required and allowable uses of funds under the TRIO program, as well as Gear Up, that's gaining early awareness and readiness for undergraduate programs. The CARES Act further authorizes the Secretary to modify the financial matching requirement for any Higher Ed Act competitive grant program as a result of COVID-19 at the request of the grant recipient. So again, they will have to make that request if they want to have that matching requirement waived. And that modification is in effect through September 30th, 2021. So that's a much longer window. And finally, under normal circumstances, educational programs offered via distance education by foreign institutions, and those offered in whole or in part in the U.S. by foreign institutions, are ineligible to participate in the direct loan federal student aid program. But the CARES Act, under these, of course, different circumstances, authorizes the department to permit both types of programs offered by foreign institutions to be eligible for direct loans for the duration of the national emergency, aka COVID-19. So, Aaron, I didn't quite hit my 10 minutes, but I think I was pretty close.
You were very close. I'm extremely impressed. Clearly, you are much better at keeping to time frames than I am. Hey, Sean, are you okay driving the slides? And I want to apologize to our listeners. We had a little trouble. I obviously had a little trouble earlier with the platform and getting the slides linked up to the conversation. Sean, are you okay driving?
Yeah, absolutely.
Very good.
So I'm going to go through basically two different acts that went through and provided numerous, tax relief to both taxable and tax-exempt taxpayers. The first is going to be the FFCRA, and then I'm going to kind of turn to the CARES Act. So the FFCRA is Family First Coronavirus Relief Act, and within that act, there's various requirements for employers to continue to pay employees if they take sick or family leave. To compensate employers for having to pay these employees during this time off, they're providing a tax credit that's a dollar for dollar reduction basically against whatever was paid to those employees. So for example, if you had an employee take a week off because of self-quarantine, or they had to take, time off of the kid's school, the FFCRA is going to provide credit. Now, I think there's some confusion on, and Aaron kind of talked about this briefly, between a credit and what's immediately available. This program allows taxpayers to basically get reimbursed right away the amount that's paid off, and it does that in two ways. First, you can go into any of your other withholdings you're required to make to the IRS for example, United States federal income tax withholding for employees, or the employee share of Social Security and Medicare that the employer remits, or the employer share of Social Security and Medicare taxes. So rather than paying those over to the IRS, you can just keep them in your pocket and use them to run your business. So this isn't going to be something that gets done like most tax credits in April of 2021 or October of 2021. This is going to be something that can provide an immediate cash influx to a company. So to the extent that this provision is applicable to you, which one of our labor and employment attorneys can kind of talk about, but basically if you're over, I believe, 50 employees, it could apply. And if you're over 500, I think it doesn't. So obviously keep this in mind. One other benefit of this credit is in the event that your credit exceeds the amount of taxes that you withheld for income, Social Security, and Medicare, the IRS will allow you to apply for it in advance right away. Now, this is on the Form 7200, and it can be filed multiple times during a pay period in order to get taxpayers the money to either satisfy what it has to pay under the FFCRA or to satisfy other business expenses. So I would keep this in mind because it does provide cash to taxpayers, and it applies to both taxable and tax exempts. The next credit that's available is under the CARES Act, and I call it the Employee Retention Payroll Tax Credit. The Employee Retention Payroll Tax Credit is kind of what it sounds like, right? To the extent you have employees that you're retaining, what the IRS is going to do to incentivize you to retain those employees is going to give you a tax credit equal to 50% of the qualified wages. Now, the qualified wages can be basically capped at $10,000, so more or less there's a $5,000 credit per employee to the extent you pay them as a result of issues related to the CARES Act, or the COVID-19, excuse me. Now, one thing to keep in mind is to the extent that anybody has applied for and received an SBA Paycheck Protection Program loan, you're not eligible for the Employee Retention Tax Credit. So to the extent that's been obtained, you're not going to be able to also double dip in with respect to this tax credit. One thing to keep in mind is about the definition of eligible employers. Now, you can get this credit, basically one or two things happens. One, your operations were fully or partially suspended due to COVID-19, or you had a 50% reduction in gross receipts. Now, while this sort of quote-unquote test may sound simple, there's some questions out there about what does it mean to be fully or partially suspended. The IRS came out with some FAQs to provide an example with respect to a restaurant. In the restaurant context, they said, hey, if you had a full sit-down dining restaurant, but because of a state governmental order, you're not allowed to have people inside your restaurant, but you're still able to do, for example, curbside pickup or drive-through or carry-out, that would be a partial shutdown. So they provided some guidance on that to sort of say who's fully and partially suspended. And the 50% gross receipts test, you would compare your gross receipts, for example, for January, February, March of 2020, and compare those against your gross receipts for January, February, March of 2019. And if there's more than a 50% reduction, you've obviously been impacted by COVID-19. Now, the big thing is going to be what is the definition of qualified wages? What wages are eligible for this tax credit that employers got to sort of keep track of. And anything paid for wages you normally pay the employees from March 13th to December 31st, 2020 are eligible for this tax credit. Where it gets tricky is they provide a special test for whether or not you have more than 100 employees or less than 100 employees. So if you have 100 or fewer employees, basically anything that's paid to the employee during the time you're an eligible employer qualifies for the tax credit. So if you're shut partially or fully shut down, or your receipts are 50% and you're less than 100 employees, you can get a credit for anything you're paying during that time period, up to the $10,000 max. Now, if you have more than 100 employees, only the wages that are paid when someone's not working qualify for this credit. So that's created some questions of, well, I have a salaried employee that's used to, he or she is used to working, 40 hours a week, but because of what's happening, they're only able to work 5 hours a week. Can I get a credit for, the salary attributable to those 35 hours? And the answer right now is unclear, because if that person is still quote unquote working and there's more than 100 employees, by the definition of the statute, the employer would not be eligible for the tax credit. Now, we expect the IRS to issue some guidance on what qualifies and what doesn't qualify. But what I would recommend that employers consider is some way to track, as attorneys, we keep track of our hours so we know how much we're, working and not working. That's not always the case. And so what I would say is for employers that want to be proactive and wait and see if there's going to be guidance that allows them to claim the credit if they're over 100 employees, potentially keep track of how much people are working and not working to help you with this credit. Now, like the FFCRA credit, this credit is also immediately available, meaning that you can basically offset it against the employer portion of any Social Security taxes. And then in the event that the credit actually exceeds that amount, you can go tap into, again, the federal income tax withholding, the employee share of Social Security Medicare taxes, as well as the employer share of Social Security Medicare taxes. And then in the event the credit even exceeds those taxes, you can go claim a refund and claim these immediate benefits. I can't harp on this enough, but this is not something you need to wait for until April 2021 to try to take advantage of it. And if you do wait, you may lose it. So what I would say is stay proactive, try to claim these credits as fast as possible because, one, they're yours, and two, they help with cash flow. The third sort of benefit we're going to talk about is the deferral of Social Security taxes. And unlike the first two quote-unquote tax credits we talked about, this isn't a waiver of the tax rather than just you can pay it later sort of thing. So as employers are required to pay 6.2% of their employer portion of any Social Security taxes on wages to employees. So the IRS has provided a mechanism for an employer to defer 50% of those taxes to December 31st, 2021, and defer 50% of those taxes to 2022. So while the taxes ultimately will be due, you do get the ability to defer those to a later point. So to the extent companies having cash flow issues, wants to keep cash on hand, is uncertain what's going to happen, this could give an employer the ability to sort of keep cash to use to pay a variety of expenses. Now, something to keep in mind is similar to the employee retention credit, the deferral is not available to the extent you obtain an SBA loan under the PPA program, and that loan's forgiven, which creates a little bit of confusion because lots of employers can start to defer Social Security taxes right now, and they won't know whether or not the loan is going to be forgiven until a later date. And so what the IRS has said is the way to interpret this provision is that any taxes deferred up to when the loan is forgiven can stay deferred. What that means going forward, though, you can no longer defer. So the example I give is if someone's Social Security taxes are due April 30th and the loan gets forgiven in June, they can still defer those April 30th taxes, but they can't defer any of the taxes that are going to be due after June. So it's something to sort of keep in mind. It provides the immediate benefit, puts cash in your hand, can help with cash flow issues. But something also to sort of consider is the fact that if you're not paying these Social Security taxes, there's no immediate deduction, right? You only get a deduction until the extent you've actually paid the taxes. So to the extent they're deferred, you're not going to get those deductions until 2021 and 2022. So employers really need to consider and take into account, you know, do I pay this now, get my deduction, possibly reduce my taxable income in 2020, or generate NOL, which we'll talk about in a second, or two, do I defer to a later point? And there's no hard and fast answer, but I will say if you're having cash flow issues, keeping the cash on hand may make more sense. But if you don't have cash flow issues, just getting the benefit of deferral may not make economic sense given the fact that you're going to be deferring this deduction to a later point. So somewhat, as I hinted to, the IRS and the CARES Act also provided a new rule with respect to NOLs. Now, NOLs in the Tax Cuts and Jobs Act of 2018 were substantially limited. They were no longer eligible for carryback. They could only be carried forward, and there's an 80% limitation. So what the CARES Act basically did is remove those limitations with respect to NOLs generated in 2018, 2019, and 2020. So now, going forward, essentially what's going to happen here is that NOLs that are going to be generated basically prior to 2018 are eligible for a 2-year carryback, 20-year carry forward, and are not subject to the 80% limitation. NOLs generated in 2018, 2019, and 2020 get 5-year carryback, indefinite carry forward, but can be subject to the 80% limitation depending upon which year they get carried back to and which year they get carried forward to. So, for example, if you're going to carry forward a loss from 2018 to 2019, that loss would not be subject to the 80% limitation. But at the same time, to the extent you carried it forward to, say, 2021, it would. And then with respect to losses that are generated after 2020, the old rules go back into place. Basically, no carry back, indefinite carry forward, and subject to the 80% limitation. Now, the last thing to sort of keep in mind, and this is something that can also provide immediate benefits similar to the tax credits we talked about, is qualified improvement property. So there was a glitch in the TCJA, the Tax Cuts and Jobs Act, that basically prevented taxpayers from taking bonus depreciation with respect to what they call qualified improvement property, which is basically improvements in the interior portion of your building subject to some exclusions. So what taxpayers were having to do was actually depreciate that. Under the CARES Act, they fixed that glitch and have now included the qualified improvement property within the type of property that's eligible for bonus depreciation, and they made that change retroactive. So to the extent this applies to any of our for-profit schools who've made improvements, they should consider whether or not they should go back and amend their returns, try to claim this deduction, which would cause a refund, and potentially put more cash in their hand now rather than waiting until a later date. So it's one of these things that, again, an overall purpose of the CARES Act related to tax is to put more cash in taxpayers' hands now to try to restart the economy, get it going, keep it going. So there's a number of provisions in here that, you know, even though they're called credits and they're called deductions and they're called carrybacks, they do provide immediate benefit that I think taxpayers and schools and everyone really needs to sort of keep an eye on because it can help with cash flow issues. Next thing I'm going to do is turn this over to Scott, and he'll talk about the Main Street Lending Program.
And I'll just jump in and say, Sean, yeah, and I'm sorry, Scott. Let me just say thanks, Sean, again. And I just want to one more time emphasize what Sean said. I mean, you can call Sean, call your accountant, call if you've got another tax resource, call them. These are not provisions that are specific to higher ed, but they have the potential to benefit institutions of higher education. So please, if you don't have your head wrapped around the various opportunities that Sean has talked about, including those that have the potential for immediate relief, reach out to somebody and figure out what they are, because we want to make sure that all of you are able to take advantage of you under the CARES Act. Sorry.
Yeah, no, one thing, Aaron, I would add on to that is, we did the best to sort of summarize these in its 6 or 7 slides, I think. There's 37, I think, or no, there's actually 55, I think, Q&As related to the FFCRA. So there's a number of issues that are still out there, a number of issues to discuss. It's not as maybe cut and dry as it may seem on paper. So definitely discuss any of these issues with myself or your tax advisor, your accountants, whoever it is, to sort of figure out a way to get the benefit of these.
Perfect. Thank you, sir. Mr. Goldschmidt.
All right. Thanks, Aaron. Thanks, Sean. So let's keep the fun going with the Main Street lending program. This is another vehicle that you might want to take advantage of, and that's a little new. So before jumping into discussion, I just want to distinguish between the Main Street program, which we'll talk about now, and the Assistance to Mid-Sized Business program. So both are discussed in Section 4003, CD3 of the CARES Act. But while the Assistance to Mid-Sized Business Loan Program has a number of terms and conditions that are written directly in the CARES Act, including some terms that are well publicized and in the news, the Main Street Lending Program was developed by the Federal Reserve using its inherent authority under the Federal Reserve Act. That means that this program has its own requirements that are not written into the Act, but as we'll discuss, have been developed and promulgated independently by the Fed. To this point, we haven't heard from Treasury about the Assistance to Mid-Sized Business Loan Program, but be sure to be on the lookout if anything comes of that, because that could be another option similar to this. So as an overview, as I mentioned, the Federal Reserve created the Main Street Loan Program meant to support small and medium-sized businesses with $600 billion in new financing. The Main Street program, there are 2 facilities that the Fed set up: the Main Street New Loan Facility and the Main Street Expanded Loan Facility. So the Main Street facilities offer up to 4-year loans for borrowers employing up to 10,000 employees or borrowers with revenues of less than $2.5 billion. The term sheets are silent as to how to count employees or whether the SBA affiliation rules, which we'll discuss a little bit later, apply to this program. These loans are not forgivable. The minimum loan for both facilities is $1 million. The maximum for the new loan facility is up to $25 million. And the maximum for the existing loan facility is up to $150 million. But there's various calculations that the Fed put out to how to determine how much each individual business can borrow as part of the program. And similar to the Paycheck Protection Program, as we'll see in a sec, borrowers apply through their banks. So the Federal Reserve has created a number of conditions for receipt of Main Street loan funds, including a commitment to make reasonable efforts to maintain payroll and retain workers, and an agreement to follow the compensation, stock repurchase, and dividend restrictions that apply to direct loan programs under the CARES Act. And there are a number of other covenants and restrictions as well in the term sheets, so we certainly take a look at all those. There's also no restriction on a borrower taking advantage of the Main Street loan if they already took advantage. Oops, I think we're one ahead. Sorry about that. There's also no restriction on a borrower taking advantage of the Main Street loan if they've already taken advantage of a Paycheck Protection loan. But as I'll explain next in a few slides, the Paycheck Protection loan may be a more advantageous option depending on your situation. Oh, the right slide. So the Fed has issued terms and conditions of the loans and had asked for comments through April 16th. So that comment period is now closed, but we're waiting to hear back from the Fed as to how they might change or adapt the terms and conditions. One open issue is whether nonprofits are eligible for this program. On April 14th, Speaker Pelosi issued a Dear Colleague letter asking her colleagues to advocate to the Federal Reserve to include nonprofits and universities in the programs. Other changes being advocated mostly by banks are to reduce the minimum loan size to $100,000 and to allow more rate flexibility. So once the Fed finalizes its terms, the loan's expected to be on a first-come, first-served basis. So institutions that are eligible or think they might be eligible should really contact the relationship bank now to determine if they're interested and start the process of gathering necessary documentation and making whatever analysis needs to happen. So after that very quick overview, we're going to head to the Paycheck Protection Program. This is hopefully a program that's a little more familiar to you. It's been out and publicized since the CARES Act was passed. So the Paycheck Protection Program offers a loan designed to provide a direct incentive for small businesses to keep their workers on payroll. The CARES Act allocated $349 billion in low interest, potentially forgivable loans under Section 7A of the Small Business Act. So institutions, including 501c3 and 501c19 nonprofits, and this also includes religious organizations, with less than 500 employees or the applicable standard size in the industry, can apply for these loans through June 30th. A few points on how to count employees. First, if an institution is deemed to have an affiliation, which generally means one entity controls another or a third party controls both entities, it must aggregate the number of employees across affiliates. Second, we've been getting a number of questions about how student workers ought to be counted in this total. While organizations such as NACUBA are advocating to exclude student workers from this number, until we receive further guidance, student workers should likely be included in any calculation. The application for the PPP is currently available and ready for to be submitted. So generally, PPP loans are capped at the lesser of $10 million and 2.5 times the average monthly payroll costs incurred in a one-year period before the date of the loan. There's no personal guarantee or collateral required for the loan, and in a recent interim final rule, the SBA determined the loan terms were 2 years and 1% interest. Allowable uses of the loan include payroll costs, costs related to the continuation of group healthcare benefits, salaries, payment of mortgage interest, rent, utilities, and pre-February 15th debt obligations. But for loan forgiveness purposes, 75% of the loan must be used for payroll. Borrowers will also not be eligible for forgiveness of loan amounts used for anything other than the allowable uses over the 8 weeks after getting the loan. Generally, borrower forgiveness will also be reduced if they do not maintain staff payroll. In terms of the number of staff, that means forgiveness is reduced if you decrease your number of full-time employee headcounts. In terms of the level of payroll, loan forgiveness will be reduced if you decrease salaries and wages by more than 25% for any employee that made less than $100,000 in 2019. And also note that there's a cure period that you have until June 30th, 2020 to restore full-time employment and salary levels for any changes made between February 15th and April 26th. Borrowers need to sign a good faith certification to be eligible for the loans, including a certification that all information provided in the application and supporting documentations is true and accurate. So as you're hopefully aware, the PPP was administered on a first-come, first-served basis. The entire $349 billion allocated has already run out, but it looks like Congress and the President have agreed to an outline to provide additional funding, which includes both $300 billion for PPP and $50 billion for the Economic Injury Disaster Loan Program, which makes for a great transition as I turn it over to Aaron to discuss the EIDL program.
And I'm going to, thank you, sir. I'm going to go through this pretty quickly because I want to get to our man on the hill and inside the beltway, Mr. Chris Murray, who I believe is indeed on the line. So like the PPP, most of you already have familiarity, hopefully, with the EIDL and have decided whether you are, it is something that you could take advantage of. The CARES Act allocated $10 billion and expanded this program, which was already in effect. Again, institutions would be applying through their relationship banks. Proprietary institutions of higher education with not more than 500 employees, subject to SBA affiliation rules, are eligible, and most private nonprofit institutions also eligible for the EIDL loans. Offer up to $2 million. The loans offer up to $2 million to pay fixed debts, payroll, accounts payable, and other bills that can't be paid because of COVID-19. Interest rate on these loans, 3.75% for small businesses, 2.75% for nonprofits. Maximum loan term, it's about 30 years. No forgiveness provisions on these, so they're not like the PPP loans. Institutions can apply for both, but the loans can't be used for the same purposes. So if we see another round of funding and you already have a Paycheck Protection Program loan and you are thinking about an EIDL loan, that is something that you can do. Again, just keep in mind that they can't be used for the exact same costs, right? So you have to pull them and use them for different purposes. There's also this concept of emergency cash grant of $10,000, and certain restrictions apply around those, and they can be used for certain purposes. Like the Paycheck Protection Program, the EIDL was administered on a first-come, first-served basis beginning in about early April. And as of last week, the SBA, again, just like with the PPP program, indicated that the funds have been exhausted. But as Scott foreshadowed, we are hopeful that there may be more funding right around the corner. And with all of that said, I'm going to turn it over to Mr. Murray to look into his crystal ball.
Hey, Aaron, can you hear me? This is Chris.
I can hear you. Yes, sir.
Okay, great. Sorry everybody for that. I joined in progress, so I didn't get to do the A/B testing on the way in. Thanks, Aaron, for all this, and thanks to the whole team. So to just give a little summary of where we are, I know you've covered a lot of this, but I'm looking at it from a legislative and Hill perspective. There were 3 bills in March. There's COVID 1, 2, and 3. We're obviously spending a lot of time unpacking COVID 3 in this particular presentation. What is up this week in Congress is what we're calling COVID 3.1, which is the top-off funding that Scott and Aaron both mentioned. So we're talking about extra funds for the Paycheck Protection Program. That's really the big kahuna because there's a long queue of folks that want funding for that program and are waiting for Congress to act very quickly. There's also expected to be additional money for hospitals and for COVID testing in this legislation. It's still a little bit to be determined what this final bill will look like. No text has been released. There is not a final deal yet. And what's also just interesting from a parliamentary perspective is how exactly Congress is going to vote on this. There's a process called unanimous consent, which can work really well if everyone agrees on a particular piece of legislation. But if someone happens to show up that has an objection, you then have to go to a roll call. And if your members are not all in Washington, that creates a big headache because you need a quorum and the other mechanics behind the scenes to do a voice vote. So there'll be a lot of interesting parliamentary things happening this week on Capitol Hill. So after COVID 3.1 hopefully passes sometime this week and is signed into law, Congress is already talking about COVID 4 and 5. They're very amorphous. A lot of folks around the country have already put in their requests for what they'd like to see in COVID 4 or 5, but those discussions are still in very early stages. But what I think it's important to highlight, our team was on a larger call with Senator Romney last week, and they really hammered home the point that the COVID 1 to 4 bills are being viewed as response measures, and then COVID 5 is looks like it will be a recovery measure. And so if you're comparing this to the financial crisis, you had legislation that happened at the end of the George W. Bush administration that was like TARP. Those were the response measures in the midst of the actual crisis to make sure that that it is being addressed in real time. You then had the Recovery Act. A lot of folks called that the stimulus bill. That was from right at the beginning of the Obama administration. That was to reset the economy and get the economy going again. We are still very much in the response phase in terms of legislation. We have not yet gotten to the recovery phase of legislation, and that will be probably starting off in earnest later this spring and into the summer. So there's a lot more to do on the legislative front. So make sure you're talking to your trade associations, to your in-house lobbyists, your external contract lobbyists, like us at Thompson Coburn, to make sure that you are surfacing your operational pain points whether they have to do with technical corrections you might need to see from one of the other pieces of legislation, COVID 1 through 3, whether you need some sort of regulatory or legislative or statutory relief to something that's already on the books, and just make sure you are floating those because there's a lot of interest in Congress on getting all of this done and hearing the pressure that you're feeling on this statutory and regulatory side. And then finally, it's just important to note that this legislation is moving at breakneck speed. As a lot of people like to complain, Congress usually moves very slow. It can take years to get something like the Higher Education Act done, and that is done with an intense deliberative process. There are many markups. There are conference committees. None of that is happening right now. These pieces of legislation are being written by leadership offices with consultation by the committees, but not a ton of consultation by committees. So they are prone to have drafting errors in them because everything is moving so fast. So that's why it's particularly important to continue your engagement, to be surfacing those operational issues that you have, because there will be many bites for technical corrections at the legislative level and also as agencies implement these programs, because some of them are written quite broadly. So that is what I have to say, and that is my crystal ball.
Thanks, Chris, so much. I personally always appreciate when you join us, because it's always interesting to hear what you have to say, and I'm sure other folks do as well. Let me just go through our TC resources real quickly, and then we'll get to questions. First of all, I mentioned earlier this is part of our higher education webinar series. We do have another entry coming up in May, actually, on cannabis and higher education. It's been planned for months. We will probably have additional webinars over the next 3 or 4 months that are sort of special. We usually don't do anything in the summer, but just given where everything is right now, please keep a watch, because I expect we'll be addressing certain topics. Certainly, if the department puts out its new Title IX rule, we will have some coverage on that, and I expect, like I say, in other areas as well. But in May, we have our regularly planned cannabis and higher education webinar coming up. Also, all of our content is available on demand, and it's free. You just go to the website, our TCLE library. I'll point out, if you look in the lower left-hand corner, we actually did a webinar a couple of weeks ago on contingency planning for distressed institutions of higher education, and had a turnaround expert and an investment banker on who do a lot of work in higher ed, who I thought had tremendous advice and a lot of very interesting things to say for institutions that are either stressed or experiencing distress. Highly recommend that one if you or someone you know might be in that boat. This webinar and all the others, again, are there, as well as the stuff that the rest of our law firm is doing that you may find of use. So please feel free to check all that out. It's free, and you can watch it when you like. Regulation is our blog. We are writing about the CARES Act and other things here. I'll also just highlight, we have 2 more that are coming out, if not by the end of this week and next week. One is on FERPA and the department's sort of COVID-related waivers around FERPA, and some of the other guidance has come out, and the other's on the CLARI Act, and sort of the response to and managing COVID on campus in light of CLARI Act obligations. Both of those will be hitting over the next 5 to 10 days, so please keep an eye out for Regulation. I'll also put in a quick pitch for those who may be looking for something positive these days, or at least a little bit of a silver lining. We did a piece in late March that just talked about the long-term outlook for higher education. It's there on the web, and you're very welcome to read that as well. Finally, if you are interested in getting alerts from us, most of you probably already do. That's why you know about this webinar. But in the event you don't, let me know, and we'll add you to our list. We typically don't hit it that often. We're trying to be respectful, although lately it's been a little more unusual just because of everything that's been going on, but we'll make sure you get these regulation alerts that tell you about our webinars or blog posts, and keep an eye out for our guides and things of that nature. In fact, we had a new updated bar defense rule reporting guide coming out soon. As some of you know, that rule is going into effect July 1, and there are some changes as to what institutions have to report to the Department of Ed, and so we'll be putting that out as well. Finally, with all of that having been said, we'll move on to questions, and it appears that we have a couple, and by a couple I mean a lot, so we'll just try to work our way through them. So can HERF funds be used for operating expenses? I'll start and take a cut at this, and then I'll ask Scott Goldschmidt for his feelings. So the first half that you're receiving now are dedicated specifically for emergency grants to students. And my response would be no, those should not be used to cover institutional operating expenses. The second half you can use for students, or you can use to offset expenses incurred by the institution in response to COVID-19 and the disruption it's caused. We do not yet have guidance from the department, any sort of meat on the bone on exactly how that half can be used, which will be potentially used for institutional expenses. My expectation is that we will see another funding and certification agreement from the department after the first half has been distributed and when they're ready to distribute the second half, and it will include parameters around how that second tranche can be used, and you'll have to sign and make certain representations about how you intend to use it. Scott, additional thoughts? Did I get it right?
I sure think you did. The only other thought is the only clues we have are just based in the statute. So the broad purpose in 18004A1 to prevent, prepare for, and respond, and then the 18004C, the kind of what may be used and what may not be used. So I think that would be a good way to allocate your thinking, and then when the guidance does come out, I'm sure it will be more comprehensive.
Thank you, sir. The next question is, are the uses at HERF funds limited? But this came in pretty early, and I think as folks know who were here for the presentation, we covered quite a bit of those limitations earlier, and we just spoke to that a little bit, right? So the limitations around the use of the student grant funds, there is some information out there already in the Act, in the agreement you signed. We are absolutely expecting further guidance from the department in the coming days. Keep an eye on the website, the CARES Act website. Keep an eye on the IFAP electronic announcements that will give you more guidance around how you can use the student grant funds, this first tranche. And then we anticipate there will be some further guidance beyond just the legislative language that Scott just referenced on the use of the second tranche. Let's see. Which association was the one in addition to NASFA to pay attention to? So it was NACUBO, the National Association of College and University Business Officers. And I will apologize again for the technical difficulties with the slide advancement early on. The good news is those slides are all in the deck, and when you download it from the resources widget, it'll all be there, and that includes on the one slide, there are two sort of looks like little web pages, and on the left it's the NASFA web page, and on the right it's the NACUBO web page, so you can click there. For distance education exclusion, does that exclusion only apply to students who are 100% online, or does it have to be prorated? So I'm not 100% sure what this question is getting at, but let me just say again, we talked earlier about whether or not, so there's some confusion about the use of these emergency grant funds and whether or not students, online students, can be included. And I think that confusion in part stems from the allocation formula that Congress used. So when Congress figured out how much to give to each institution, right, and directed the department to sort of carry out that exercise. And if you go to the department's CARES Act webpage, which I'm looking at right now, they actually have a couple of PDFs there. One is the allocations and the other talks about the methodology. But even in the statutory language of the CARES Act, one of the things Congress said it was going to do is it was going to look at Pell recipients institutions had, and that was how they were going to sort of weigh the distribution formula. And they said 100% online students will be excluded from this formula we use to figure out how much institutions will get. Okay, so they did exclude online students when they decided how much money each school would get in their formula. But there is nothing that precludes institutions once you get that money. So let's say you get $10 million. There's nothing that precludes you from then saying we're using a distribution formula and we're going to include our online students. right? I mean, the costs have to be, or the grants are supposed to be used to cover expenses that the student incurred as a result of the disruption on campus from COVID-19, right? And some people may say, well, we think our online students likely incurred less expense than our on-ground students. And whether that's true or not, and whether you want to include that in your formula is totally up to you. But the critical point here is not to conflate the formula Congress used for figuring out how much schools get with your own formula for who you want to distribute emergency grants to. Your formula can include online students. Let's see. Does broad use of funds include loss of revenue due to reduced enrollment? So Scott, let me ask you this. All right. Let's say, I feel like this question is getting at the second tranche of funds, because we've already made clear you can't use the first tranche for emergency grants to students to offset any kind of loss that the institution has sustained, right? I mean, those funds are for students and their costs and expenses due to disruption. But the second half, we do think institutions will be able to use to offset their costs and expenses, and we just have a small number of limitations. So the question here is, do we think that second tranche, it might be possible to use it in some way to offset the loss of revenue due to reduced enrollment? I'm interested in your thoughts on that.
Yes, and I think this kind of gets at the last question we talked about as well, but to the extent that loss of enrollment is due to COVID-19, you're using funds to respond to COVID-19. There's nothing in the statutory language that would prevent this use. As we talked about earlier, the Department of Ed may come and kind of qualify that or give their own opinions for it, but the best reading that we have right now, our thinking, is that institutions can broadly use funds for anything except for the specific prohibitions in Section C that Congress allocated, if it's to prevent, prepare for, or respond to COVID-19.
Agreed. All right, so next question. With regard to housing, we talked about one of the appropriate uses of the emergency grant funds for students is to cover housing costs. Again, assuming these housing costs have been incurred as a result of the disruption on campus due to COVID-19. And here the question is, when we're talking about housing expenses, eligible housing expenses, is that only for on-campus students who've had changes? What about off-campus students who potentially lost income or job? I don't believe there is anything that would restrict you from or preclude housing costs incurred by online students, right? I mean, or off-campus students. So you could have someone who's online, you could have someone who's off-campus. Theoretically, any of those folks could have incurred, as a result of the disruption, the COVID-19 disruption, some sort of expense that relates to their housing. Right. Maybe they lost that federal work-study job, and now they don't have some way to keep doing that job, right? Although in that case, as Katie pointed out, I guess we would continue to pay them, so maybe that's a bad example. But here's the point. If you have online students or off-campus students who theoretically have housing expenses that resulted from the disruption on campus due to COVID-19, there's nothing that would prohibit a grant from being used to cover those expenses. I should get away from off-the-cuff examples. Let's see. Oh, somebody said, I'm aware of at least one college that has received its funding in G5 as of today. So that's great news. We had not heard that, but that's good to hear. Thank you for that. Let's see. Many of our staff is working at a distance. Is there any guidance on how quickly student grants must pass through the institution? Like anything that says it has to happen within a certain number of days? Scott, what do you think about that one?
No. So nothing that I've seen has any mandate, but to the extent that you can get it through as expeditiously as possible and you can document that maybe it takes a little longer because your staff is at a distance, that fulfills the purpose of the statute and kind of helps with all the other issues that Aaron talked about during his presentation.
Yeah. So let's see, a couple others I think we can knock out quickly. Is the funding only for Title IV eligible students? I mentioned that earlier in the conversation. No, it is. There is nothing that prohibits you from taking all your students into account when you distribute these funds, as long as they have qualified expenses and they are current students. Whether they're Title IV or not is not a distinction that the law draws. Is it appropriate to hold back a portion of emergency needs for which students would be required to apply? There's nothing that prohibits you as an institution from holding back a pool of funds. And I mentioned you might do that until you get further guidance on undocumented and non-immigrant students and just confirm their eligibility. Although, again, right now we believe they are eligible, but there could be some question, so we expect the department to clarify. You could hold back some amount for special need, anticipating that maybe you go ahead and distribute 90% of the funds now because you want to get them out the door, and then you go through a process of solicitation to students to try to identify those who may have some level of extraordinary need. And you hold back some amount to try to address those particular needs, and you build in some sort of more sophisticated needs analysis or application process to try to ferret out that information. There's nothing that would prohibit you from creating a holdback or dispersing these funds in tranches over time. Again, just keep in mind, we've noted we think getting more out the door sooner rather than later is positive for a lot of different reasons, consistent with congressional intent, probably good for you from a PR perspective and for other reasons as well. Let's see. Is there any downside to drawing down all the money at once? I think it's anticipated that institutions will, sort of mechanically speaking, that the funds will show up and that they'll pull them all down into, hopefully, if they can do it, a separate account, and then proceed with the distribution process. Scott, have you seen anything that suggests that institutions can't draw down the entirety of these funds at the same time?
No, nothing. Yeah, no, nothing that says they can't. The only caution there is, I think as Aaron mentioned in his presentation, that you'd want to kind of run your models to make sure you have everything right. If you do draw it all down and you do one big disbursement, to the extent that you get something wrong, that could cause some thorny issues. So drawing something down and putting a little bit in reserve maybe, or figuring out that you're really sure about your models is a recommended best practice, but nothing definitive about how institutions go about drawing down the funds.
So what about students who were already enrolled in online programs? So we're talking about folks who, were in a 100% online program, presumably. And the question says, it would not seem like there would be a great deal of expense incurred as a result of disruption to campus operations due to COVID-19. How should need be assessed for those students? Well, I'll start out by offering, I think that the campus concept, when we talk about what is your campus, I think that means everything, including the virtual platform. So let's say you have a 100% online program, but as a result of COVID-19, you have faculty and staff who are no longer able to be there. Somebody got sick, the person who typically taught this program, and it had to stop for a week while you transitioned it to another instructor or professor. Now, I can imagine scenarios where COVID-19 has impacted and caused disruption on your campus, including for your online students, right? If that resulted in qualified expenses, then you could issue them amounts, or they could accept amounts to cover those qualified expenses. It also may be, some of the qualified expenses that are talked about included technology, if they needed to acquire some sort of new technology because you had to move to a different platform, childcare, again. But you raise, it's a great question, right? If you've got someone who is online, is it conceivable that if the institution, if there were no disruptions to their online platform, to their instructors, to the way things were being done for that person, is it conceivable they would not have any expenses as a result of COVID-19, its impact on the campus? Yeah, it is. And that may be something you want to take into account when you're coming up with your distribution formula. If you've got 5,000 students on campus and 500 online, and 500 online haven't been impacted in any way, you might consider whether you would create a second tier or grant amount for those students, understanding that, you think that the for them are likely less. Let's
Aaron, this is Scott.
Yeah, please.
Oh, just want to jump in one thing. So Congress might have thought the same thing in terms of their allocations and why they specifically excluded exclusively online students. So completely agree with everything Aaron said, that it depends on how you want to set up your funding formula, but it seems like at least the statutory language could give you some cover if you want to provide that second tier for exclusively online students.
Yeah, that's a great point. And there are two lessons we can derive from Congress's allocation formula, right? I mean, the first is they used Pell Grants as a proxy for need. And the second is they excluded online students, presumably because they felt like they would have fewer qualified expenses. So when you're devising your system for distribution to students and your own sort of way of assessing need, you don't have to use those criteria at all. But to the extent you employ them for those purposes, you, as Scott said, you probably have, quote, some cover because it seems consistent with the reasons why Congress used them in their allocation formula. Let's see. Have any institutions been successful in completing the application for funds on grants.gov? Yes. That, I believe many institutions actually have had success, and someone earlier indicated that at least one institution, we think now, and maybe more, have received funding through G5. But I don't mean to make light. Many institutions of higher education don't have familiarity with grants.gov. I've had many clients who've been very frustrated with this process and also working through and sometimes needing to fix information in Duns & Bradstreet and SAM.gov. And so I don't mean to make light of the question in the least. I do believe many institutions, because remember there are thousands, I believe many have had success in getting those certifications uploaded, but I also believe many more have been frustrated in their efforts and some have not yet had success despite days of trying to get there. The good news, again, is that this isn't like PPP or the EIDL program. It's not first come, first served. This money is now for your institution, and it's there for you. So, and while we want to get the students to need sooner rather than later, at the same time, it does not have to get out tomorrow or the next day. We're still waiting for guidance from the department. There are lots of schools still working through these processes, including registering on grants.gov and getting everything in order. So I believe you have time, and in fact, and by time I mean days, right, not weeks or months, but I think you've got days to think through this. And as we encouraged earlier, I mean, I think institutions should be very thoughtful and deliberate in formulating their protocols and thinking about how they're going to manage this process and how they're going to document it and make sure they're keeping all those appropriate records. Let's see. Do you recommend that grants to students? Yeah, I like it. I mean, it's not required, at least we haven't seen anything from the department yet that suggests it's required. I heard at least one trade association last week indicate they thought maybe the department would land there. My concern is just if you're going to use the ledger card in their account system for your student account system, you have to be really careful, right? Because if you pull for funds and it runs through your process and gets netted out against an outstanding balance, and what you're essentially doing is just issuing what's like a stipend to a student. Now it's all wrong, right? It just seems easier if you keep it totally outside of that system. That having been said, we understand some schools won't be able to set up separate bank accounts and may not have distribution systems that will facilitate that. Can students get funds now under the 2019-20 school year and then get more funding in 2021 for expenses, or is the emergency grant a one-time thing for students? Scott, I'm curious in your thoughts. My understanding is if a school wanted to devise a system where they've got a year, they could hold back funds. It's really not based on award year, right? I mean, it's just based on the year from when you sign the agreement, the calendar year. So I would think you could have a school that decided to devise a system where certain disbursements of these grant monies were occurring in a subsequent award year.
I sure agree with that, but I think as you cautioned correctly in your presentation, the funds have to be used for the statutory purpose of the CARES Act and what schools certified to. So for grants, for expenses related to disruption of campus operations due to coronavirus. So to the extent that as you go further in time, those expenses might not exist anymore, that's certainly a caution you should consider while you're allocating your dollars in that way. but certainly something that's possible to do.
So the next question is it advisable to extend grants to students above and beyond the 50%? So that's the, the statutory language says at least 50% has to be used of the allocation for the student emergency grants. So can you go beyond that 50% for purposes of satisfying past due balances owed to the institution? So I believe that the 49%, we'll say, so the at least 50% that you have to use for the student emergency grants, right? That goes to the students. For the remaining amount, as we mentioned earlier, I mean, I think there will be great opportunity to use that to offset institutional expenses and potentially to apply against outstanding balances for student balances of the institution. I mean, but if you were going to do that, and I think there will be opportunity to do that, my advice would be to approach it in a way that the 50% that's being used for the institution and to satisfy past due balances is not being dispersed in a package in a way that makes it look like the student emergency grants. In other words, my concern would be if you got audited on the back end, it might be difficult to tell what was what, and it might inadvertently you end up with a situation where someone's looking through records and says, well, wait a minute, this was a quote student emergency grant, but it appears that it was used to satisfy a past due balance. I would want to keep those extremely separated. And I would want to advise whatever system you use for applying that second 50%, the second tranche, to offset institutional expenses. I mean, my preference would be not to use a mechanism for doing that looks like student grants, right? I mean, my guess is most institutions, and we're going to get more guidance, I'm sure, from the department, but my guess is most institutions can figure out a way to appropriately offset COVID-related expenses with those funds, institutional expenses, we're talking about with the second tranche, right, without having to make them look like student grants, and to do so in a way that's very easy to, from an account perspective and a tracing perspective, to say this was the second bucket and these funds were used to offset institutional expenses in this way. I just worry about, meeting them as student grants or something that looks like student grants, and ending up with some sort of confusion on the back end. Scott, thoughts up front?
No, I mean, that sure makes sense to me. Yeah, no, nothing else to add on that one.
All right. So it's 1:56. We're getting pretty close here. I'm going to try to just grab a couple more questions here, maybe that look a little different. Let's see. How long should we keep records available for audit? That is a great question. There are probably record-keeping requirements to regulations that are cited in Attachment A to the certification agreement. You can talk to your counsel, or it's got government contracts, kind of person to ask. But my guess is that they most certainly are keeping requirements, retention periods. Will accreditation bodies be included among those entities that could examine these records? I expect that accrediting bodies, shooting from the hip here, probably are not included among those that are contemplated by the law, but I would expect as a general matter that your accrediting bodies, I mean, given the scope of their examination, particularly during their periodic reviews and your renewal accreditation cycle and when you're filling out a self-evaluation report, it's hard to see how that will exclude this event and the funding that has come in, because accreditors look at financial strength, among other things, and they're going to want to understand. They look at your financials. They're going to understand all of that. And you're talking about lots of money coming in and lots of money going. I don't have any right under the specific government grant regulations, but my expectation is accreditors probably already have enough authority under their own standards to ask some of those records. Let's see. All right. Just trying to.
Hey, Aaron.
If we can pick up one. Yeah, go ahead, Scott. No, go ahead. I'm just looking for a couple more questions to hit. Go for it.
Sure. There was a question about public institutions and the FFCRA tax credit. FFCRA tax credit is not available to the United States government, the government of any state or political subdivision thereof, or any agency or instrumentality of a state. So depending upon your facts and circumstances, to the extent a school is deemed to be an instrumentality of the state, then I believe there's a rev rule out there, like 57-128, that has 6 factors to determine whether or not a school is an instrumentality. But if your school was an instrumentality, it would not be eligible for FFCRA tax credit.
And there's another one. Sean, let me ask you this question too while you're going. Will employers have to provide a declination of the PPP prior to submitting requests for tax credits?
A what from the PPP?
A declination. I assume the question is, will they have to somehow prove that they didn't take advantage of or take out a paycheck protection loan prior to submitting a request for certain of the tax credits?
I don't think you can prove a negative. I don't think they're going to be issuing letters saying you didn't take a PPP loan. So not that I'm aware of at this point.
Got it. But it is true. My recollection was that certain of the tax credits, it was sort of one or the other. That you could take advantage of the paycheck protection loan program, or you could seek certain of the tax benefits. So I guess the question is, if certain of the tax benefits, part of the eligibility criteria, are not having taken out one of those loans, obviously the institution will have had to have made a decision.
Right. So like the employee retention credit, you can't get if you take out a loan. I don't think, this SBA is going to issue you a letter saying you did not take a loan, but if you did not take one, you are therefore not ineligible, from the retention credit, meaning that if you otherwise satisfy the requirements of the retention credit, you're going to be fine. But no, I don't envision I don't envision them basically requiring people to get letters from the SBA saying they didn't get loans, if that's what the question is.
Yeah, I think that's right. All right, good. Well, I apologize. I mean, we got so many questions. We're not getting to all of them. But if you want to reach out to us and chat about